Now, good morning everybody. Before we start proceedings today, could I simply say that we have with us today the 6th year class of Modern Studies from Boroughmuir High School here in Edinburgh, and they're very welcome, and I do hope they find this one day in the life of a public inquiry of some information and assistance to them. So with that, Mr. Turner, could we turn to today's business, please?
My Lord. Good morning, my Lord.
Good morning.
My Lord, this morning we have a panel from the Scottish Courts and Tribunals Service, Mr. Eric McQueen and Mr. Noel Rayfish.
Good morning, Mr. McQueen. Mr.
Morning.
Rayfish.
Good morning.
Yes, Mr. Turner.
Thank you, my Lord. Good morning. A brief reminder before we begin. This morning's hearing will be transcribed. I will try and speak slowly, and if you could do likewise and clearly, then we'll get on fine. Mr. McQueen, if I could come to you first, could I ask you please to state your full name and please tell us your position or former position with the Scottish Courts and Tribunal Service, please.
Okay, my name's Eric John McQueen, and I was Chief Executive of the Court Service during the pandemic period, prior to my retirement in August last year.
Thank you. And Mr. Rayfish, could I ask you to do the same?
Yes, thank you. I'm Noel John Rayfish, and during the pandemic I was in the role of Corporate Secretary to the Scottish Courts and Tribunal Service up until January of 2021, and then I was in the role of Interim Deputy Chief Executive.
Thank you. And what is your current role?
I'm now real Deputy Chief Executive.
Thank you. You have both given statements. You've both given statements, I should say. You, Mr. McQueen, you have given a statement to the UK inquiry previously. Is that correct?
That's correct.
And that statement, my Lord, is lodged with the Scottish inquiry under reference SCI WT 05741 and is being adopted, my Lord, in avoidance of duplication in the normal way. And Mr. Rayfish, you have given a statement to the Scottish inquiry, and that statement is under reference SCI WT 04791. Thank you. Everything in those statements will form part of the inquiry's record. We're going to touch upon a number of matters this morning. Within those statements, we may not get to everything in the available time, but we'll do our best to touch upon as much as possible. In beginning, could I first of all ask a few questions about who or what the Scottish Courts and Tribunal Service is? I'm conscious that there are a number of lawyers in the room who will be fully familiar with SCTS, but some of our guests may not be. Mr. McQueen, could I ask you, first of all, constitutionally, what is SCTS?
SCTS is a non-ministerial corporate body. We're not a formal part of Scottish Government, part of the Scottish Administration, and we were created under the Judiciary and Courts Act 2008. Essentially, SCTS provides the infrastructure and the support and services to allow the courts, the tribunals and the OPG to operate. We're governed by a judiciary-led board, which is chaired by the Lord President, which has other judicial members, myself as Chief Executive at the time, members of the legal profession and some independent non-legal people who are not associated with the justice system. The board is supported by four committees, an Estates Committee, a People Committee, an Audit and Risk Committee and a Remuneration Committee. And as Chief Executive, I have 6 Executive Directors at the time who formed part of the executive team who were responsible for the day-to-day operations and the running of the courts, tribunals and Office of the Public Guardian.
Thank you. You've preempted a number of my questions there, Mr. McQueen, so that's very helpful. You mentioned there the boards. Is it the board on a day-to-day basis that would be running the organisation?
The board is more focused on the sort of strategic direction, so it's up to the board to set the corporate strategy for the organisation over the coming 5-year period. And the board meets about 6 times a year to review performance against the strategic priorities and to make key decisions for the organisation, I say with the day-to-day operations being delegated to the chief executive.
At the time, that would be yourself?
At the time, that was myself, yeah.
Yeah, just to add to that, the board itself has a set of standing orders, and they incorporate a scheme of delegation. Now, that scheme of delegation delegates various functions to the staff of SCTS, and one of those delegated to the chief executive is the day-to-day organisational and operational management of the organisation. And that's essentially the power that allows the chief executive to be able to make decisions as to allocation of resources, operational matters and such like, at those times when the board itself isn't meeting. So there's very much the board has a key role in setting strategic direction and making the most key strategic decisions, but a lot of the day-to-day business is then delegated to Erica, as was in his role as chief executive, and then sub-delegated on to members of the executive team and the organisation.
Thank you. So you've mentioned there that's how matters are ordinarily arranged and organised. We're obviously here to discuss the pandemic period. Were there any changes to that organisational arrangements or augmentations to those organisational arrangements during the pandemic?
Not so much changes. I mean, quite clearly the board and the committees continue to operate throughout the period of the pandemic. We moved immediately to a virtual basis. I guess the key thing which we implemented was the SCTS strategic incident management team. That was activated on the 27th of February, and that was chaired by myself. I had the executive directors and a range of key other operational directors, and essentially that group's role was to coordinate the activities and the response to the emerging pandemic. That was part of our contingency planning arrangements that were already in place, so it was quite well grounded in clear procedures to put that team in place. And that team met, I think it was about 190 times over the period of the pandemic to coordinate pretty much on a daily basis the delivery of services within the courts, but also the interaction with a wide range of organisations and a wide range of partners. And quite clearly worked very closely with the senior judiciary, particularly the Lord President, the Lord Justice Clerk and Sheriff Principals, on the management of business and how we were going to structure and how we were going to change to deal with the emerging health situation.
Thank you. You used the word activated there. Do I understand from that that this was a pre-existing arrangement that was activated?
Yeah, so this is part of the business continuity plan that we have in place. That the first step we made when we have a critical incident is to form the strategic incident management team as being the group that will then manage and lead that incident through to closure.
Thank you.
I was just going to say that the SIM team is something that is recognised in the organisation's business continuity strategy. So it wasn't a new thing being imposed on the organisation, but it stood up in those situations where it's felt that having the collective knowledge, experience and wisdom of that senior team and other supporting officers directed towards a critical incident would add value to the organisation's normal management response, and that was very much the case here. So just to give, for instances, prior to the pandemic, and it had been used in activation in relation to issues such as severe weather, significant system outages. So it was a reasonably well recognised and well understood mechanism for us to use, although it would be fair to say that prior to the pandemic, we never thought we would have a SIM team activation that lasted for 2 years and met on over 190 occasions.
Being part of the incident management plan that was pre-existing, were there plans in place that were used during the pandemic, or was this a novel situation that hadn't been planned for?
I think the answer to that is a bit of both. So the organisation has a business continuity strategy, which I think is something that we lodged in evidence. It also mandates each of the organisation's individual business units to produce a business continuity plan. Now, those plans we have a number of core principles, and one of them is around about consequences, not causes. So we say it's not possible to plan for every type of event that might affect the organisation. However, it is possible to anticipate the impacts that events could have on areas such as people, premises, systems, partners, utilities. So on that basis, we asked each area of the business to produce a plan. We also asked each area of the business to, as part of that planning process, to rank in order of priority its critical activities. So to make that as simple as possible, really saying to each part of the operation, if you could only do one thing, what would it be? If you could only do two things, what would the next thing be? So that ahead of any significant incident, we have a good understanding of those things that are most important to maintain and the level of function and the level of systems and support we would require to maintain those those things. So all that planning was in place and was used to good effect. However, it would be untrue of me to say that those plans and those arrangements were such that we ever anticipated to flex them for a period of 2 years plus. So it gave us a good head start. It was based on resilience and business continuity doctrine, the integrated emergency management doctrine that the Scottish Government recommended at the time. So we felt we were in a fairly solid place, but I think in common with a lot of organisations, the pandemic actually tested, stretched and ultimately improved our business continuity arrangements into the future. Although at that point in time, it felt like quite a significant stretch and change. But no, just to sum up, yes, we had a planning approach. We had plans. They helped us identify critical activities. They helped us prioritise business. But there did come a point where we needed to start making additional decisions and new plans, which the business continuity plans had never anticipated, because the scenario planning on which they were based, the level of disruption was not of the duration and severity that the pandemic visited upon us all.
Just to pick up on that, was it anticipated within the plan that for example, the courts wouldn't be able to operate in person? Yes.
In terms of premises disruption, we had a working assumption in there, which I will probably struggle to get perfectly correct from memory, but it was something like about 40% of premises unavailable for a period of up to 2 weeks. Obviously, when we moved into the initial phase of lockdown and we consolidated into hub courts, we actually had a significantly larger number of premises and that closed for a longer period of time than ever anticipated. So there were arrangements in place that put us in the right mental space to be able to work out what to do in terms of dealing with premises disruption and court closures. But we had never anticipated that level or scale or planned for that level or scale ahead of the pandemic period itself.
Thank you. The SIM team, as I understand it, therefore, is providing some sort of oversight of the operational response to the pandemic. Were there any particular priorities set by the SIM team for SCTS?
Yeah, I mean, we set 3 high-level, what we call the sort of strategic priorities, and first and foremost, it was about public health. So it was making sure that we took every step to maintain the health and the life of people within the courts, the staff, judiciary and court users. Secondly was to maintain as much essential business as possible, so trying to identify what was a critical business that, given the constraints placed upon us, we could manage. And thirdly was to make sure that we tried to organise the business in a way that would facilitate a recovery programme once the health restrictions started to ease and allowed more business to come. So those were our guiding principles that we tried to apply throughout the pandemic. So absolutely safety was the #1 priority, followed very closely by the essential business and then planning for recovery.
We will obviously touch upon, because those were the strategic matters, they obviously flow through matters during the pandemic. But perhaps I can ask a general question just at this point. Are you able to offer any view as to whether those strategic priorities were met by SCTS during the pandemic?
I think we believe they were. So we certainly maintained throughout the pandemic safety as our #1 priority. So every decision that was taken, every change that we made to court business, every change that we made in terms of increasing or decreasing depending on the pandemic at a particular time, safety was the absolute priority, there is no doubt. And through it all, we set we moved the level of essential business to match what business could be accommodated depending on the prevailing health conditions. And certainly I think as we can see now, then the plans for recovery have largely been successful. So we saw a significant recovery in a very short space of time, both in relation to civil and criminal business, and we're now well on the way to recovery, in terms of civil and tribunal business, and we're now well on the way to the recovery in criminal business.
Thank you. I think I would just add to that again, the priorities that the individual business units of SCTS had set up were very, very useful in this regard, because as Eric mentioned, the 3 strategic priorities the organisation set, they were in deliberate order of priority. So making sure that everybody was safe was number 1, making sure that the most essential business could be maintained was number 2, and then facilitating recovery was number 3. Because we were in a position of having a good understanding of those aspects of business which were the most critical, we were able to quite quickly focus and try and maintain those services, albeit in different and unique ways, which meant that we were able to concentrate quite significantly on element number 1, the safety aspect, because we already had that. Okay, what are the most important things to maintain kind of in the bag, and then the work on recovery, as Eric said, I'm sure we'll probably come on to later, was more significant than anyone could have anticipated at the outset. But we were in a good position by virtue of some initial steps we took in terms of understanding case backlogs and measuring and collecting data, because at least that put us in a position where we were able to kind of get a grasp of what we were dealing with, and therefore what kind of steps might be necessary to address the consequences that had arisen.
Thank you. If I could now turn to the question of the powers of SCTS. You've mentioned that SCTS is not part of the Scottish Government, it's part of the Scottish administration, but you've also mentioned that significant changes were required to the operations of SCTS. Did SCTS have the power to make those changes appropriately?
In some cases, yes. In some cases, no. So there are explicit powers within the legislation for the Lord President and the Sheriff Principals in terms of the efficient disposal of business within the courts. Court programme lies entirely in the hands of the judiciary. So there were certain plans that we could put in place to try to change and adapt the way business was being managed, but equally some of that relied on legislation. So therefore there needed to be discussion with the Scottish Government in terms of the types of changes we wanted to bring in and why we would need some emergency legislation to allow those changes. So, for example, the electronic exchange of documents, bringing in remote attendance and excusing attendance at hearings, the use of national custody jurisdiction are just some examples of the types of things where once we had identified what the best plan was, we had to have discussions with government in terms of the support and legislation that would be required.
You've mentioned there, and it may just be a corollary of the examples that you've given, Mr McQueen, but the matters that you referred to in terms of the changes in terms of legislation appeared to me to relate to matters of court procedure as opposed to the operations of SCTS in terms of its core functions. Was that a distinction, or was that just an example?
I think it was just an example.
Yeah, the constitutional position is a little bit complex. It might be worth just saying a little bit about that. So I have an analogy that maybe some of the young gents over there will get in terms of a football game, that SCTS isn't the teams, that's the parties to a case. We're not the referee, that's the judiciary. We're the event managers, we're the guys that run the stadium. So in terms of SCTS's specific statutory purposes, We're there to provide the people, the services, the systems and the administrative support to make sure the courts effectively function. Working in tandem with the judiciary, which is something we had to do at every step of the pandemic. We have the collective power to do quite a lot in terms of court programming, the standing up or standing down of business, the opening or closing of courts. That's not something that is absolutely within the remit of SCTS, but it was incumbent on us and the judiciary to work very well together to use the powers that we each have independently to make sure that we operated as safely and as effectively as we could. So in terms of those core powers of SCTS to do the things it does in terms of people, staff, services, there wasn't really a need for significant changes in policy or legislation. However, in terms of being able to flex the way in which the courts operated, make use of remote and electronic submission and things like that, those were areas where in discussion with the judiciary it became quickly apparent to us that there were a number of steps that could be taken which would mean that we were much more able to achieve the strategic objectives that had been set than if we were just to remain looking at those core purposes. So it was very much a case of kind of collaboration and joint working, which then obviously had to engage government to get us into the place to say, well, given the scenario we find ourselves now facing, here are things that we think could be done in order to most effectively facilitate and manage business as effectively as possible. So you very quickly in these circumstances get into a situation where the importance of working well with your partners, with the judiciary facing in as SCTS and the management of the courts, but also government facing out and the prevailing policy and what was acceptable at the time become really, really important, and that led to a very busy and very critical phase early on in the pandemic where there was a lot of work done.
Thank you. It's implicit from what you said there that there was a lot of working with a number of partners, as you mentioned, the judiciary and also the Scottish Government in terms of legislation. Could I ask, out with the pandemic in ordinary times, what sort of level of engagement does SCTS normally have with the Scottish Government?
Pretty regular and quite frequent engagement. So primarily through the Justice Board for Scotland, which we sit on along with the police and the Crown and a whole variety of other organisations, which is chaired by the Scottish Government. So the Justice Board meets on a sort of bi-monthly basis. So that's one of the main focuses. But it's fair to say that we have pretty much daily interactions with government on a whole range of initiatives that are being taken forward.
Thank you. You mentioned the Justice Board for Scotland. Could you just explain what their role is?
Yeah, the Justice Board for Scotland was formed quite a number of years ago, and their role is to try to coordinate the different parts of justice to make sure we're all working in a common direction. So it's trying to achieve the overarching strategy for justice that's set out by Scottish Government, by Scottish ministers, which we play a part of in terms of parts of the delivery where that impacts on the court service. So the Justice Board tries to bring that all together. With the impact of the pandemic and the real focus on criminal justice, where we saw there was going to be the biggest challenges, we formed a subgroup called the Criminal Justice Board, which was a smaller collection, mainly of chief executives of the operational arms of justice organisations and the Director for Justice, to look at collectively how do we pool our thinking and our resources to try to make sure we can manage this in a joined up, holistic way, rather than each organisation going off and trying to carve out their own path.
Thank you. It sounds like in ordinary times you've got quite a lot of engagement with the Scottish Government, but could you tell His Lordship, was there any change to that engagement during the pandemic?
Change in what way? In terms of
change in terms
volume,
of volume, frequency?
Yeah, I mean, there was certainly a change, I would say, in terms of the volume. I mean, there was very few days, particularly in the early parts of the pandemic, where there weren't discussions taking place with government. So part of that was trying to explain the context we were trying to work in, the changes we were making in terms of the programme of business, the impact it was having on courts and court closures, and equally part of that was actually then trying to plan out and think, well, okay, but what are the changes we will need to bring in so we can actually make some of the changes to our overall system. So the volume certainly increased quite significantly from the onset of the pandemic onwards.
Thank you. And how was that engagement ongoing? Was it yourself, Mr. McQueen, or was it other members of SCTS that were engaging with the Scottish Government?
I led on some of the engagement, but equally it was spread across the entire executive team. So Noel, for example, was a member of the COVID-19 subgroup, which was again set up by Scottish Government. I think it met weekly during the early stages of the pandemic, and different operational directors were involved with government and other organisations, depending on whether we were looking at a focus on courts or tribunals and OPG. So it really spread across the whole senior team in the organisation.
Just to add to that, that there's within SCTS we have a small team whose normal day job is to, or part of their normal day job is to monitor and react to Scottish Government consultations, to offer views on policy proposals coming from Scottish Government on the one hand, and on the other hand also to face into the organisation. So when changes to law or procedure are proposed, the right guidance and information is provided to our staff to make sure that those can be effectively implemented. So that small legislation implementation team, as it was called, rapidly became retasked in that early stage of the pandemic, as Eric says, to work on quite a lot of the considerable detail there was, because it was sometimes quite straightforward to say, you know, we would like to be able to have electronic submission of something, but then to actually work through what that meant in terms of what needed to change and to make sure there were no adverse consequences required quite a lot of detailed black letter work. So that team in particular were kind of directed to that under the stewardship of Eric and the support of the SIM team.
Thank you. One of the important dates, just to give His Lordship a bit of an indication in terms of the timing of some of this engagement, one of the important dates, I think the easiest date that a lot of people can pivot their memory around is lockdown on the 23rd of March 2020. I wonder if you recall when the engagement with Scottish Government regarding some of these matters commenced. Was that before, at or around that time?
It was before that. Probably in February time was when we started to get real concern about the emerging threat. We saw what was happening in other parts of the world. We can see the impacts starting to come through in terms of what was coming back from Italy. So I think there was a real concern actually that this was now going to hit us, and it was going to hit us quickly, and we had to start moving forward. So there was discussions taking place with the Justice Board in the early part of February. As I say, we instigated the SIM team in the later part of February, and discussions took place on quite a regular basis there forward. Noel chaired a group of organisations from the police, from the Crown Office, to start looking at what our contingency plans were going to be collectively and how they now needed to be enhanced. We had meetings with the Lord President, with the Sheriff Principals. We had a joint meeting where we brought them together with the Lord Advocate and Director for Justice in the probably about the middle part of March, to really set out what the plan was starting to look like as how we were going to apply to that. At that stage, we're starting to discuss the move to the 10 hub courts, and that was something that we were able to implement very quickly after the 23rd of March. I think by the 25th of March, we had moved to the 10 hub courts as being our first step. So there was a lot of thought done in a very concentrated period, probably from about mid-February until that point in March where we had the lockdown imposed, and then the discussion continued at some considerable pace thereafter. Thank you.
Turning then, you've mentioned one of the changes that was happening around that time at the initial period of the pandemic, or when the pandemic was starting, I suppose, at that point. Can you talk His Lordship through the stages of those changes? You mentioned there the 10 hub courts. What other changes were initially made by SCTS to?
Yeah, so some changes that we made initially, and this was in the week prior to lockdown, we, in discussion with the Lord President, ceased all jury trials. So no new jury trials started after, I think it was around about the 16th of March. We restricted the level of summary trials that were currently taking place, and we then took the decision to move to the 10 hub courts. Again, the 10 hub courts is back to our principles about putting safety first. So the position on lockdown was very much the stay-at-home message. Actually try to maximise or minimise the amount of people that were in a working environment. Moving to the 10 hub courts allowed us to release a significant number of staff and judiciary and partner organisations to actually stay at home. I think we only had about 10% of our staff actually in buildings during that initial phase of lockdown.
You mentioned there that those changes were happening before the actual lockdown on the 23rd. By that point, were you already anticipating that something like lockdown would be coming?
I think we were anticipating it was coming. By that time, I think the announcement had already been made that schools were closing. So already, big events were being cancelled, sportings were being cancelled. So by then, we had a real sense of anticipation. And at that time, anxiety levels were incredibly high. Already there was concerns about staff, there was concerns about judiciary, there was concerns about witnesses turning up at courts, accused turning up at courts, because the whole nation was in a very heightened state of anxiety with knowing what the impending pandemic was going to bring.
Thank you. So we then move forward through lockdown into the first few weeks of the pandemic proper. What other changes were happening around that time?
So what we tried to do in that time is one, make sure that we had the right digital technology in place. So starting from the early part of March, we were procuring laptops, distributing laptops to staff and judiciary to ensure that as far as possible they can work at home. We were making major upgrades in terms of our network infrastructure because we knew we were going to be moving into a virtual environment. We had to make those changes. We procured WebEx as being our key organisational tool that we're going to start to use for virtual hearing. So an awful lot of work within the digital space was being really accelerated as we went into March and went into that the period where we moved to 10 hub courts. We focused really on the essential business and how we could manage essential business. So on summary crime, for example, we restricted it to custody trials and what were classed as priority trials where it involved children or domestic abuse or sexual offences. The number of trials dropped incredibly. I mean, in each month we were probably running somewhere between 10 and 20 trials, whereas normally we would have run 500 or 600 in a month. So it had an enormous impact on level of business. Again, in civil and tribunals, it was making sure we had the right priorities in place. So on tribunals, the priority was to make sure that we could deal with mental health hearings, which have got a statutory requirement to be held in 5 working days. So they moved very quickly to a telephone hearing system, and all those hearings took place. None were cancelled during the lockdown period. And on civil, both in the court of session and the sheriff courts, discussed with the judiciary what the priorities were going to be and what work could be managed at that time. At the same time, very much with an eye being to where do we go after lockdown. So while we were on one hand running, trying to deliver the business that we could that was essential, at the same time we were trying to work out as soon as lockdown starts to ease, how do we start to reopen our courts and how do we plan to bring more business back out. And clearly one of the big issues at that time was about jury trials. We were facing a position where jury trials could not exist within the existing court arrangements, and we had to find a way forward and a solution to solve that.
Thank you. We'll come back to jury trials because I appreciate that's quite an important part of SCTS's response. I'll also come back to what was happening in the courts, but if I could just stay for a moment with the remote business that was taking place at that time. Do you recall how long it took to get the WebEx system up and running?
It got up and running in different phases. So I think by April we had the WebEx operating in the inner house. We moved it quite quickly thereafter to certain parts of tribunals. I think the health and property changes started using it round about July. So we moved it on an incremental basis. So telephone hearings were the very quick and easy way of getting the business back up, and that was the initial priority. The WebEx then got rolled out over a period of probably about 6 or 7 months across the entire organisation to deal with all civil business, and then starting to get implemented wider within tribunals.
Thank you. You've mentioned there obviously WebEx, and you mentioned in passing the telephone options that were being implemented concurrently with that. Were any difficulties reported in respect of either of those systems by either staff or users?
I think the truthful answer is yes, simply because of the speed of the change. So this was change that was brought in within a short number of days. We didn't have clearly written procedures. We didn't have the training in place that you would make with a normal rollout. So yes, it was very bumpy. And there's absolutely no getting away from that. Enormous credit to staff in the judiciary who took it like a duck out of water. They really tried their best to make it work. And they really supported the people, the parties in the case, to help them. We had a fantastic technical team that was supporting both the staff in judiciary, but also working with any partners any times they had difficulty. So the problems were less about the technology. The technology was absolutely sound and the technology operated. It was more about getting people up to speed with a change in a very, very short time scale. That's the thing you would normally have planned over a 6 or a 9 month basis. Essentially, we were cramming it into the 6 or 9 days.
Yeah, there were some real challenges, as Eric says, just around the fact that you were trying to land all of these elements which you would normally have planned for over a longer period of time. And that also meant that because you were not in a position to be able to sort of phase and test in the way you might have liked, that when an issue did arise, diagnosis of it could be a little bit more tricky. So that was something that we quickly learned as we went on that. Our digital team, for example, were able to procure a piece of software which was able to work out if there was an issue with a connection, actually kind of which leg of the connection the issue was with, which then meant that we could in all honesty, run around in the background and try and get that bit of it fixed. And quite regularly, and this is no aspersion to anyone, it was quite often individuals, parties, people who were finding themselves having to do things at home that they never thought they'd have to do. Although we were advised on several occasions that we managed to get people quite a significant upgrade to their broadband as a consequence of some calls and some diagnostics we were able to share. So I say that slightly glibly, but it was that was just a real example of something that could make a whole set of proceedings fall down if you didn't have a way of dealing with it. So, as Eric says, it was those people issues and it was those problem diagnostic issues that probably tripped us up in individual cases. In terms of the actual sort of quality and selection of the technology and the processes that eventually built up round about it, those seem to have stood the test of time to the extent that they're still being used in a number of procedural hearings and other instances just now. So by a mixture of good diligence and a little bit of fortune, we backed some products and approaches there that have turned out to be very sound.
Thank you. At this time, again, we're just still in the initial stages. Where were the SCTS staff working?
Again, it varied during that particular period. So initially, on the initial period of lockdown, we only had about 10% of staff in the office. So the vast majority of staff were at home. There was big parts of our organisation where we knew that was going to be long term. So Saughton House, which was owned by government, was closed in April when we knew that would be closed for a long time. We had 150 staff based there. So we knew there was going to be a need to have a significant number of staff working at home for a long time. So again, we put the technology, we provided furniture for staff in terms of setting up home office equipment to have them working in the long term. Some of the staff started coming back to the buildings, particularly as we got to June time when we had the reopening, where we moved back to probably having about 40 or 50% of staff back in the building. So it fluctuated at different periods, but settled out at most of the pandemic for about 50% of staff being based in offices and probably about 50% being home.
Thank you. You've mentioned there the point where we start to see staff coming back and other users coming back into the courts. What steps were taken or what provision was made? You've mentioned health being the first priority. What provision was being made at that time?
Yeah, I mean, that was an enormous piece of work, again, taken forward in a very short space of time, where we had to carry out very detailed risk assessments on every single building. So we had to get floor plans for the whole buildings. We had architects, engineers going through the plans to identify how we were going to operate within the requirements. So how we were going to achieve 2 metres physical distancing, how we were going to have people queuing, how many people could we have working, what seats couldn't we use, what rooms could be occupied by a certain number of people. So we had an enormous piece of work looking at all the arrangements to physically get people back in. We then had to map out and tape up all our buildings to identify where the safe areas were, where the 2 metres were, signs on doors as to what ones can be accessed, what can't be accessed, one-way systems. We've done significant work with our cleaning contractors about how we would enhance our cleaning regime. So we looked at the British standards for cleaning, and we put enhanced cleaning arrangements in place, both at night time but also cleaning during the day on all the key touch points. Our technical property teams looked at all our heating, our ventilation systems, and switched them all to run at 100% fresh air. So we turned off any recirculation, we turned off any thermal heating, and we had fresh air running through all our buildings. Where we didn't have that type of ventilation, there was no mechanical ventilation, we looked at other ways that we could create ventilation within buildings, whether it was opening doors, opening windows, creating a draft. So an enormous amount of work took place, and one that we've done in partnership with the PCS. So we had an agreement in place in terms of the opening of the buildings. We had an agreement in place in terms of the risk assessments that were being carried out, and all of those were in place by the end of May for the buildings opening in the first 2 weeks of June.
Thank you. Could I just add to that, to say that the basis on which we determined the measures we would have in place, recognising that we're not public health experts, we didn't have a centre of public health expertise within SCTS, so all the approach we took was always based on the Health Protection Scotland guidance for COVID-19 premises and non-healthcare settings, and we were very, very clear that at all stages of the pandemic we kept that advice under review and made sure we aligned with it. As I said, conscious of the fact that we weren't public health experts, so we needed to rely on the advice that was prevailing at the time.
You've mentioned there aligning with the advice. Can I ask, was there any point where additional provision was made? For example, did you require staff to vaccinate, or did you require masks to be worn at a time when those were optional?
In terms of vaccination, we strongly encourage staff, but we also respect the rights of individuals. It's not something we would have a power to compel individuals to make a decision on, but we provided access to all the relevant guidance and information that was available at the time. In relation to face coverings, initially we made sure that every member of staff had access to face coverings from March in 2020. Around about August 2020, we changed our guidance to strongly encourage that face coverings be worn while on SCTS premises, and I'm sure people will maybe recall that there was a kind of a debate ongoing at that point in time about the efficacy and effectiveness of face coverings. Our change in August kind of reflected the fact that we felt that the tide was turning and that there was increasing evidence that would be necessary, and then that was recognised in October of 2020 when Scottish Government with our support passed some regulations to make court facilities facilities in which it was mandatory for face coverings to be worn.
Did you have any difficulty sourcing those face coverings?
We didn't, to the extent that we initially provided washable fabric face coverings for all staff, which we were able to procure. We do understand for those where it was mandatory earlier in the pandemic, there were difficulties sourcing reusable face coverings. By the time we got to reopening, and by the time it got to the point where there was mandatory usage, those supply issues weren't an issue for us, because we were able to call on procurement contracts that are facilitated for the Scottish Government, and the supplies seem to be okay. So generally speaking, no.
Were any steps put in place to deal with outbreaks in the court estates?
Yes, we were fortunate in that we didn't have high levels of outbreaks, but again, in terms of the Health Protection Scotland guidance for non-healthcare settings, their instruction and therefore the guidance that we introduced made clear that should there be 2 confirmed cases within a location within any 14-day period, then that should be treated as a suspected outbreak and reported to the local health protection team. So as part of our daily situation reporting that that the organisation ran throughout the pandemic. All cases were reported in, and if any area did reach that 2 or more trigger, the local sheriff clerk or the local senior manager would make contact with the health protection team. In a number of instances, the health protection team more or less just acknowledged that and asked for reassurances that we had relevant provisions in place. I think on a couple of occasions from memory, additional questions were asked and visits were carried out. But in those instances, the safety arrangements that the health protection teams found on the sites in question were found to be sufficient.
Was there any provision to track people who may have been affected by outbreaks in the estate?
Oh, sorry, yes. From
Safe to go.
Yes. From, to begin with, it was an individual reporting mechanism that each business area will be reporting into to the SIM team or to the administrative team that was supporting our SIM team, or not only on staff cases but on any suspected or confirmed cases of court users. So at that point in time, we were managing that on a kind of by location basis, so that if we had intelligence we felt was of concern, it would be reported into the local health protection team. From around about October in 2020, we took advantage of the development of one of the contact tracing services that had sprung up as a consequence of the pandemic. So we instigated a system whereby we requested that everybody using the court buildings checked in and checked out using a system called Safe to Go, which involved a QR scan and then just logging your name and a contact number. And for those people who couldn't do that, we had staff on the doors who would do that on the person's behalf. That information was then shared independently with that with that firm, and only released to health protection teams if there was a request direct from the health protection teams as well, because we needed to make sure that the way in which we were managing that was GDPR compliant as well.
Thank you. You mentioned a number of the measures, social distancing, PPE, cleaning, and the like. Was there any feedback received from staff or other users in terms of any difficulties that were experienced, in terms of people maybe not complying with regulations and the like?
Yeah, I mean, I think it was a couple of different things there. I mean, so I think initially it was all very new for people. It was all very difficult. It was actually quite scary for some people. So initially it took a little bit of time just to get used to it. So sometimes there were some, perhaps what you might call non-compliance, where people would just forget. They would just breach 2 meters. They would go into a room where it was only 4 people and there was 5 people. So it took a little while for people to get into it, but once they did, it actually stuck pretty solidly for quite a while. Where we found there was some occurrences where it was getting problems was probably towards the end of 2020, just before we went into the second lockdown. I think by then the public generally were getting quite tired of all the restrictions. I think we saw it in virtually most of the social areas we were in, that actually there was less adherence to the physical distance that there had been in the past, and we started to see some of that encroaching into the court area. Not so much, I've got to say, with our staff or judiciary. I think we had very clear lines with our staff, but we found it with other court users that sometimes perhaps it wasn't being stuck to as religiously it could. So we came out, particularly just before the start of the lockdown, again with some sort of strong messages and strong advice about the need to adhere, about this is actually everybody protecting each other. We had a video put out by the Lord President, again stressing the need for people to adhere to the particular measures, because it was the safety of everyone involved, and that certainly had the desired effect. The instances we had where there was any concerns about non-compliance pretty much evaporated away at that stage.
Were there any concerns raised with SCTS by users regarding I suppose the sufficiency of premises that was causing them to potentially breach regulations? To give an example, was there any feedback in terms of the availability of accommodation for people to meet with their clients, for example?
Yeah, I mean, that was one specific issue that was raised. I think that was raised probably around about that same time of the second lockdown. And it was raised by solicitors who had concerns about actually the space available within the court building. It's quite a tricky one because it never has been a responsibility of the court service to provide facilities for agents to meet their clients. The view of the judiciary is always that instructions should be taken before you come to court, but by its nature and the type of business, custom and practice dictated that actually that happened within the court area, whether within communal areas or corridor areas. So we didn't put a blanket ban. We encouraged people where they could to take instruction before they came to the court building. But in our larger court buildings, we tried to make additional accommodation available. So some of the civil courtrooms, for example, in Edinburgh and Glasgow, which were not currently being used, we made some of those available to the legal profession to have discussions with their clients. So we tried not to come down like a ton of bricks on it. We tried to accept that, okay, it's not a formal responsibility for the provision, but where we can add some flexibility, then we'll try to do it. That wasn't possible in every court building, because in some court buildings we just simply didn't have the capacity. But where we could manage it, we did try to put some measures in place that would assist.
You mentioned a moment ago January 2021 and 2020, 2021, and the then Lord President getting involved in some of these matters, and indeed I should say, Mr. McQueen, you reported commenting as Chief Executive on that in relation to the Lord President reminding users, if I can put it that way, of the potential for them to be found in contempt for breaching those regulations. Did SCTS receive any feedback from either users or staff in relation to that announcement?
I think the view of staff was very supportive. I think they had genuine concerns about safety in some of the breaches. So I think from their point of view, to have a very strong judicial direction coming out was deeply reassuring. And I think that played the same to most of the other participants. I think for the legal profession, I think to be fair, I think they found it uncomfortable. I think they found it as a direct or directed towards them, which in many cases it was, because actually that's where some of the issues came from. So it did cause some stumbling relations, and we had quite significant discussions with the law site about it. I think everybody understood through time that it's back to our number one priority. Our number one priority was safety. Sometimes some of the messages might upset people, but if safety is your number one priority, then you've got to stick with it.
Thank you. If I could turn, I was going to say back, but I suppose turn on to the question of remote juries that you mentioned. I wonder if you could explain to His Lordship, first of all, I suppose in broad terms, how did that come about?
Yeah, it was quite a world-breaking approach, to be quite honest. We were clearly in a position where we couldn't run juries within the traditional court environment. A group was formed that was chaired by Lady Dorrie and the Lord Justice Clerk, brought together a whole range of organisations involved within the system, the legal profession, the police, the Crown Office, Rape Crisis Scotland, Victim Support Scotland, to try to bring people together to find a collaborative way as to how we can try to solve this problem. Initial thoughts, and we had these up and running by the latter part of July, was to see whether we could spread a traditional jury court, not in one courtroom, but spread it over 2 or 3. So we had different models running, one in Edinburgh, one in Glasgow, one using a 2-court model, one using a 3-court model, where we would have the jury in different locations. In Edinburgh, they sat in the public gallery, and they used a different court for deliberations. In Glasgow, we tried to use 3 courts where we had the jurors actually out with the courtroom, and we just basically video linked them into the main courtroom. The trials that run were actually quite successful. So they done their job, they ran to conclusion, people were generally satisfied with how they operated. The challenge for us is it takes up either 2 or 3 courtrooms to run trial. So in the long term, it cuts your capacity down to a third, which was not a sustainable position given the size of the backlog. We had looked at a whole range of different options that we had discussed with government, and indeed government held a round table looking at options about reducing the jury size, putting additional powers to sheriffs rather than solemn business, considering having juries, trials that didn't have a jury, and these were all options that were considered dismissed. So we were stuck with this issue. We had to find a way of working through how we could free up capacity that didn't involve using 2 or 3 courts. And we took the view at that stage, well, if the jury can be out with the courtroom, why do they need to be in the court building? Where else could we have a jury based that would allow them to participate in a trial? And cinemas sprung up as being the ideal solution. Cinemas were lying empty. They all had excellent technology, they all had great seats, they all had large screens, they had cracking toilet facilities, they had individual access to all the cinemas, they had a network that was spread across Scotland. And we knew that even if restriction measures ended, then it's probably a sustainable model that could continue, because cinemas are not jam-packed during the day. Their main business model is in the evenings and weekends. So while we had looked at other options such as university complexes or educational complexes, our concern was as soon as they go back, then that facility doesn't become available. So the cinema model had the idea, one, it was attractive because of the excellent facilities, but also it looked like it would be sustainable in a longer term if we had to run that. So this group got together. Again, we carried out risk assessments. We done an enormous round of work round about the technology, how things were going to be viewed, how we would identify the different participants within the cinema screen. So the cinema screen was split into the 4 parts, so that the jury could always see the judge, the accused, whoever was speaking, whether it was defence or prosecution, and another screen that would display productions and video evidence. And we had a separate area within there where they could carry out jury deliberations, being socially distanced, using microphones as we are using today. So it was actually a very good solution. We got the first jury centre up and running in Edinburgh, I think, towards the end of September. The second one in early October, and by November we had 16 trial courts running for the High Court, which was just taking it back to its operational capacity. We replicated the same solution for the sheriff courts, and by February 2021 we were back up to the 18 court capacity for sheriff and jury. So it was a solution which I think everyone was pleased with. It was a solution that was entirely safe. It was a solution which actually the feedback from the jurors was very positive. I think the fact that it was out of town, it was car parking, they weren't able to get public transport into town centres, and they were in an area which was largely empty with lots of space, gave them a more feeling it was a secure environment. So I think from all fronts, I think people saw this as being a very sensible step to get jury business back up to the capacity levels in what was a relatively short time. And I suppose quite remarkable that during the period, the best part of 2 years we were remote jury centres, we dealt with something in the region of about 2,500 trials, and that accounted for some 35,000 jurors sitting in cinemas watching or taking part in a trial, which again was really helpful in terms of some of our remote evidence. There's always been concerns about over a video link, can you actually properly assess the credibility of witnesses? Well, 35,000 jurors done it for 2 years. There was not a single complaint, there was not a single appeal point about the use of remote jury centres, which I think really commends it as I think what was an excellent solution.
The only thing I'd add to your very full response here, Eric, was to pick up on that point that obviously there was a degree of reticence that when you do something new like this and it's something very, very significant, is it going to have an impact on the efficacy or veracity of the process? So gathering and analysing data was really, really important as well. So it was very reassuring for us to see at the macro level at least that there was no sudden or no real change at all in terms of the kind of proportion of verdicts that were reached as a consequence. Now, obviously, every case turns on its merits, but when you have a sufficiency of numbers, you would expect that if the system was providing something similar to that which went before, to not see a radical change in those figures, and we didn't see a change in those figures at all, which again was something that was reassuring.
Thank you. And I think also I'd just like to commend everyone who took part in this. In normal days, like the pandemic, this would never have got off the ground. It would never have been an issue. But I think everyone genuinely was determined to try to find a way through. So people were very, very willing to consider things that in normal days they might not were. And the level of shared working, shared thinking, people's ability to compromise, to come up with different solutions to make it work was absolutely fantastic, and that applies across the board to the legal profession, the third sector, everyone involved. It was a real collaborative effort to put this in place.
We've spoken about, looking back at the SIM team priorities, we've spoken about the health efforts that were made in the court estate. We've spoken about maintenance of business, either through juries or other techniques. The third is, if those are successful, minimising the accumulation of backlogs so far as possible. First of all, could you explain to His Lordship, were there any backlogs, and to what extent were backlogs accumulated during the pandemic?
Yeah, I mean, there were backlogs that accrued in different parts at different times. I say on civil and tribunal, we had a relatively short period where backlogs were accruing, but because we were able to move very quickly to either telephone conferencing and then through time onto the virtual WebEx system, those backlogs were dealt with in a relatively short space of time. I think we'd said in the statement that in the sheriff courts, for example, the business performance in the civil courts was actually better in 21-22 than it had been pre-pandemic, so they actually recovered in a fairly short period of time. The big concern for backlogs was in criminal business, where we saw a significant increase in terms of the levels outstanding. We done an awful lot of work from the start from our data team, our management information team, trying to model what that was going to look like over a 3-5 year period, which gave some quite scary options in terms of the level of business that was accumulating. And that enabled us both through the Criminal Justice Board and also then directly through the Scottish Ministers to secure funding for the recovery programme. So a recovery programme for criminal business was put in place in September 21, which brought in an additional 4 High Courts, 2 Sheriff Solemn Courts and 10 Summary Courts. And that operated through until April 2023, where we switched because somebody was starting to recover, and we added on a further 2 High Courts and a further 6 Sheriff and Jury Courts. So the position that we are in at the moment is still a significant increase, but actually most of that generated by business levels that had been increasing anyway. So at the height of the pandemic, we had something like 44,000 scheduled trials outstanding, against what was our normal average of about 20,000. And at the moment, we're currently down to 21,000. So arguably, the vast amount of the backlog has now been dealt with. What we are seeing, particularly on the Solemn side in the High Court and in the Sheriff Solemn, is the continuation of the increase in level of indictments that are coming through. Now that was evident before the pandemic, so already both the High Court and Sheriff and Jury were under pressure at that particular time. When the pandemic came in, there was a few month period where indictment levels dropped, but very quickly they got back to the normal level, and we've seen a quite steady 10-15% increase in the level of indictments, most of them related to sexual offences, which comes as no great surprise to anyone. And that looks like it's going to be a continuing theme to come. So I think from our perspective, in terms of backlogs, most of the backlog that was caused purely by the pandemic has now largely been dealt with. What we've got is this additional surge in business coming through on the Solemn side, both in the Sheriff and Jury and in the High Court. The Sheriff Summary side is getting close back to where it is. And with the new case management that's now being rolled out across the country, we think that will quite comfortably take care of the summary backlog. So that's less of an issue. Our main concern now is about the future years and how we can provide the additional capacity to deal with both the High Court and the Sheriff Solemn. So, I mean, by comparison, there was around about 400 scheduled trials for the High Court outstanding pre-COVID. I think we're currently sitting about 730. On Sheriff Solemn, it was round about 500, and I think we're currently sitting just over 1,100 at the moment. Now that's come down quite significantly because of the recovery programmes in place, but it's still a significant amount, and quite clearly impacts on the waiting time for trials, which in most cases are taking more than twice longer than they were pre-pandemic, and quite clearly for accused, for victims of crime, for witnesses, the longer it takes to get to the trial stage and get to a verdict, then the more difficult it is for them. So we're acutely aware that this is not something that's sustainable, and we need to maintain and indeed increase the recovery programme to deal with that increasing level of business.
Thank you. Backlogs are obviously a negative effect coming out of the pandemic. Were there any positive effects in terms of SCTS's practice or changes in terms of approach?
I think personally, I think there's many positive effects. I think the biggest or the key effect has been the move to virtual hearings. I think that's been very successful across the entire organisation. So now, for example, in the High Court, preliminary hearings take place virtually on a daily basis. So the accused in custody is no longer brought from prison unless there's going to be a guilty plea taking place. Police and medical witnesses within the High Court now give their evidence remotely from their place of work. So police officers or surgeons or forensic scientists no longer need to travel to the High Court for a day or 2 days. They stay in their place of work and they give their evidence for the 45 minutes or their hour or whatever it is. There will be occasions where you need to have them in the trial court, and that's accepted. If their evidence is particularly complex or particularly lengthy, it may be sensible to have them there, but for the bulky witnesses, they can give their evidence remotely. We still adopt the remote balloting of jurors. So prior to the pandemic, we would bring in at least 60 jurors to select our 15. We now do that remotely. So those jurors now don't come to the court. They only come to the court once the ballot has taken place within the court environment. Within the court session and the sheriff court's virtual hearings, particularly for procedural, are now run-of-the-mill. So in the sheriff court, about 50% of all hearings take place by WebEx virtually. In the court session, I think it's about 40 or 42%. In the sheriff courts, we no longer bring people who are in custody for any procedural hearings unless there's a need for them to be there or unless they're pleading guilty. And likely on sentencing hearings, both in the High Court and in the Sheriff Summary Court, if individuals are in custody, it's a single individual, then by and large, they are just video linked into the court to have their sentence given. So I think some real big benefits there. I think the introduction of electronic documents, particularly in civil side, is being well received by everyone. I think in a short space of time we will be in a position where the vast majority of civil business can be done online. We've now introduced a case tracking just a few weeks ago into the court session, and very soon we'll be working on getting initiating documents in this part to close that overall package. So for me, I think the adaptation of digital technology, I think, has been a massive benefit. I think, to be honest, the partnership working has been a real benefit. So yes, there were times it was very difficult, and we had lots of difficult conversations, whether it was with other justice organisations or the legal profession or the third sector. But I think they had to be had. I think we've all come through it. I think we've all matured, and I think now there's a much greater openness to share. I mean, just a very practical example. I mean, during COVID, we set up weekly discussions with the Vice Dean of the Faculty, the Chief Executive President of the Law Society, the Crown Agent, and myself. They were informal meetings just to get a heads up, find out where we are, and they still take place to this day. We've moved them to monthly now rather than weekly, but we just get so much benefit out of people just being open and honest, talking about their fears, their concerns, their apprehensions, and doing it in an open way. So for me, the partnership working is really grown through the pandemic, and one that we want to hold on to. And I think that real spirit of we can do things and make them happen. You know, the remote jury centres, again, people would never have believed it could have happened in that space of time. It wouldn't happen at that pace now, but we need to apply that same endeavour and that same spirit to bring change in and make sure that change doesn't take 2 years or 3 years to deliver.
Thank you. Mr. Rakers?
I just wanted to chip in with a couple of other points. Certainly, some of the early changes allowing electronic submission are things that we have worked with the Scottish Government to make sure are maintained. Prior to the pandemic, we were still in a position where, for quite a lot of civil business in particular, you needed wet signatures on hard copy pieces of paper, and you would have seen many people coming in and out the court with large bundles of paper. I'm not saying that's completely a thing of the past. Some people like to cling on to their paper, but in terms of transmission, it can be submitted online, and the execution can be valid without a wet signature. Similarly, we have a system known as the Walls of Court, which prior to the pandemic was literally important notices that were to be posted, declaring certain aspects of business would be stuck on the walls of the corridor of the court. We're now in a situation where the Walls of Court have moved on to the SCTS website, which in terms of transparency and accessibility, we think is a far better place for us to be in this day and age. And the final thing I'd add, while endorsing everything that Eric said, is round about flexibility. There are some of the legislative and policy changes that were made, allowing business, for example, to be transferred from one area to another, while we would not intend for those to be used on a regular basis. For example, recently when there was the red weather warning and we had to close a number of courts for public safety reasons, we weren't in a situation we would have been in several years ago where we were looking and going, well, we need a court in that particular area, that particular sheriffdom, to remain physically open, because that is the only way to lawfully hear that business. We're now in a situation where that can be much more simply transferred or managed remotely, competently. So there's been some benefits for longer term resilience, as well as the kind of modernisation, convenience benefits that Eric mentioned as well.
Thank you. One of the things that the SCTS provides, you mentioned, is its people. There's obviously been a lot of hard work done over the pandemic. I wonder if you're able to tell us whether there have been any effects on the SCTS staff, either during the pandemic or in terms of the recovery period.
Yeah, I mean, I think it's been very tough on staff. The level of change that we brought in and the speed of change was quite incredible when people's jobs were changing overnight. I don't think there's anyone in the organisation whose job now is the type of job it was 5 or 6 years ago. So everybody's job has changed to a significant amount. The amount of technology we're now using is vastly increased again where we were 4 or 5 years ago. So I think there's been a lot of pressure, a lot of stress on staff. We tried to take our foot off the gas up a little bit and try to build on the good things we had in place, make sure we had the right training in place, make sure our processes were getting there. I think also for the staff there's a lot of pride in what they've achieved. So yes, it was tough, it was difficult, but I think staff come through it with some real pride, that actually they made things work in a way that they didn't think they could make things work. I think for some staff, home working has been a boon. So we have a hybrid working policy in the organisation that allows certain staff to work from home for certain periods. No one works from home all the time. Our expectation is that staff will be in a building 2 or 3 days a week, and likewise at home. But again, those are some quite difficult things because not everybody in the organisation can access that. Some of our staff and clerks of the High Court, for example, need to be in the High Court. They can't be working from home. So it's this whole thing about sort of fairness and equality. I think with a lot of our people's issues, I think that not everybody can access the same people policy all the time. So people at the moment may be in roles where they can't access hybrid working in 6 months' time or a year's time. They may well be. So again, it's this balance thing. So we have tried to work to really explain to staff some of the change we brought in. It has been difficult. We carried out our own internal evaluation just shortly after COVID that Noel led in it. If I remember right, about 80% of staff were saying that the changes brought in worked well, and they were good for the organisation. I think there were some positive things there. The results of our people surveys over the last couple of years have been increasing and going in the right direction. So again, I think there's a feel-good factor. I think we're moving into a new place now. I think thankfully COVID is now pretty much a distant part of people's memories, but there's no doubt it was very, very tough on staff. And we did try to go out of our way to support staff as far as we could. And I would call out PCS, our union. I think we had an excellent relationship with PCS during the pandemic. I met every week with the chair and the vice chair of the PCS to discuss the impact on staff, to discuss the staffing issues, discuss safety. And again, lots of things we would disagree on, lots of things where we had difficult conversations, but at the end of the day, we came to good conclusions and good results. So yeah, I really take my hat off to the staff in the organisation and the judiciary in the organisation, who I think really came together as one to make it work.
Thank you. We have literally about 1 minute left. Time flies when you're having fun. If there is anything that you would like to highlight in that minute to His Lordship, we've covered quite a lot this morning, but if there is anything else that maybe lessons that you might think His Lordship might want to take into consideration, now would be your very brief opportunity.
Okay, if I've got 1 minute, I'll try and make it 50 seconds now. I guess there's two things which, as Chief Executive, I guess I was frustrated or disappointed that we didn't deliver on. One of them is fully virtual custodies. I think the day of moving people about in vans over Scotland, the impact on their mental health, their access to services, it's just ludicrous, to be quite honest. I wish we had done more on that. We've done a good job during COVID. We've got good video links working. We had about 5,000 cases that went through that. But I think we've stalled a bit on moving to a fully virtual solution for custody courts. And I think there's enormous benefits to the accused. I think enormous savings that could be made out of that. And that's one area I would really like to see some focus on. The other area is virtual trials. We had a small number of virtual trials which didn't really bite, didn't really get any great work. We've done some work much more recently looking at could we have a different model for domestic abuse, where we have specialised sheriffs, specialised prosecutors, all trauma informed, trying to work in a way where we've got a completely virtual environment for domestic abuse, where people never need to come into the work environment, and we get consistency in terms of the service and delivery. So if there's two areas where I think I wish we'd be able to make more progress, it's on a move to fully virtual custodies and trying to find a more holistic, trauma-informed way of dealing with domestic abuse cases.
Thank you. Mr. Rayfish, have you anything to add to that?
Two things I would say. Firstly, I would just want to put on record my personal thanks, but also from SCTS to all the incredible working relationships we had with a number of partners, because I think stocks of the word unprecedented are now back in. It was certainly overused at the time, but it certainly feels like it was a completely unprecedented time. And the nature of working relationships, almost everyone you dealt with came to the table looking to see how could we improve the situation. And I guess my one final observation would be to say that we as an organisation, and I'm sure other organisations, have done a lot to learn lessons, and I would say we're in a stronger position than we were ahead of the pandemic to deal with a number of the particular aspects it dealt with. I think it's for me personally shaken my confidence a little bit in terms of how far your business continuity planning can take you, because actually when you're faced with an incident as significant as the COVID pandemic, no organisation, no government is ever going to fund the level of latency that would be required to seamlessly move into an alternative set of arrangements that will deal with it. So I think we now maybe sleep a little bit less easier if you work in the planning and business continuity side of things, because you're aware that there could be another incident. It may be health related, it may be related to something else in future, where you will apply your best case scenario planning, you'll put everything into place that you've already developed, but you may still find yourself in the position we all found ourselves in the early stages of the pandemic, saying this takes us so far, now we need to sit down and look at what we've been presented with and what we do next. So business continuity is a crutch, but you can't walk as fast as you normally do with a crutch. So we're in the situation of realising that, and really trying to redouble our efforts to be as well prepared as we can.
Thank you both. My Lord, I don't have any further questions to ask this morning, unless your Lordship has anything to add.
Thank you, Mr. Turner, and thank you both very much indeed. I think perhaps I should say something. As you're both aware, I worked as a judge for the first 2 years of the pandemic, and so can actually testify to a lot of what you're saying being accurate. But Also, I think, for the benefit of the young people here, as certainly the oldest person in the room, and as the person who probably had more experience than anyone else in the course of session for well nigh 50 years, 40 odd years, you moved things forward technologically and process-wise more in the 2 or 2.5 years of pandemic than they did in the other 44 or 45 that I experienced. So that's really, A, quite commendable, but B, quite encouraging for the future as well. Very good. Thank you both.
Thank you.
Just after past. Now, good morning.
Good morning, my lord.
Now, good morning.
Morning.
Now, when you're ready, Miss Trina.
Thank you, my lord. Giving evidence this morning is Joy Dunn from the Public and Commercial Services Union. Is that right, Joy?
Yes.
Thank you. You provided a statement to the inquiry which forms part of your evidence today, and for the benefit of our records, the reference for that statement is SCI WT 0474 50 and then a 1. Your evidence today, as you know, is intended to supplement that statement, so please be reassured if there's anything that we don't cover today, your full statement remains before the inquiry. But you start by telling us in the statement that you are an industrial officer employed by PCS, is that right?
Yes.
And you tell us you've held that role, I think, since 2011.
Yes.
I wonder if you perhaps can begin by briefly telling us what PCS is and does.
PCS is a trade union that represents civil servants across the whole of the UK, including some non-departmental public bodies. We have 280,000 members across the UK, with 25,000 in Scotland.
And in terms of your participation and your evidence that you have provided to this inquiry, the evidence that you have given relates to your members which are involved in the justice sector, is that right?
That's correct.
And what organisations are those members employed by?
The Crown Office and Procurator Fiscal Service and the Scottish Courts and Tribunal Service.
You go on in paragraph 9 of your statement to tell us the makeup of and the numbers involved in that. And I think we see there that there are 700 members employed by COPFS and around 1,000 members employed by SCTS. Are you aware of what percentage of the workforce that makes up in terms of your members?
So in the Scottish Courts and Tribunal Service, we have sole recognition. We're the only trade union in that organisation, and our membership density is about 56%. In the Crown Office and Procurator Fiscal Service, we have joint recognition with the FDA, represent lawyers, and we have over 60% membership density in the Crown Office.
You also tell us that as part of your role, going back to paragraph 2 of your statement, that during the pandemic you transferred to what is termed a bargaining role. Can you explain to us what that involves?
Yeah, so in PCS as a trade union, there were many roles throughout the whole organisation, but when the pandemic struck, it was decided by the General Secretary that we had to have a coherent response to that pandemic, so staff were split into 3 teams, organising our membership, central response team to respond to members' queries, and a bargaining role, which would be an officer who had interaction with employers during the pandemic, initially dealing with pandemic issues which were, you know, at the top of the agenda at that time, but normally bargaining role means negotiations over pay and terms and conditions. But during the pandemic, obviously the priority was the pandemic and the health and safety of our members.
Can I take it from that then that you were involved in discussions between both SCTS and COPFS and liaising between your members about the issues?
Most of it was done by our reps on the ground, but if there were difficulties that needed to be escalated, then they would come to me as the full-time officer. And I also dealt with the Scottish Government at a strategic level in terms of rolling out the coronavirus protocols that apply to the Scottish devolved sector of employers across government.
And in collating the response that you have prepared helpfully in the form of your written statement, can I take it that you have used the information provided to you by those reps in providing that evidence?
Yes, we pulled all that together as a collective because obviously I don't work in the court service every day and don't have the technical experience or knowledge that they have. But, you know, the evidence was pulled together in conjunction with our reps on the ground.
Thank you. Your statement, aside from explaining your role and the role of PCS, logically then moves on to at paragraph 14 telling us what happened at the very beginning of the pandemic. And His Lordship has heard evidence yesterday and earlier this morning about both COPFS and SCTS and what they did as an immediate response to their operations. But you, of course, discuss, and your interest, I think, lies in how those changes affected those who were working for those organisations. And the first thing that you touch upon within your statement at paragraph 15 is a split in immediate impact between what are court-facing and non-court-facing roles. I wonder if you could tell us about that distinction.
So the court-facing roles are the staff who have to be in the court every single day to prepare the court, to have an interaction with legal staff, the police, the court users, the kind of external stakeholders, as well as defendants and victims. And then the non-court-facing staff are those, for example, who work in facilities management or HR, who don't necessarily have to be in a court. And in fact, you know, the HR staff within the court service are not actually based in a court. They're based in a government building out at Sopton House.
So in terms of there being a differing impact, can I take it from that then that there were some people who required to continue to physically attend at a court building,
yes,
and some people who didn't?
Yes. So those who didn't need to attend court were asked to remain at home and to work from home, and there was a rollout of equipment to allow people to do that. I mean, pre-pandemic, these non-court-facing staff would have attended the office every day, but the court staff, there is still a requirement for them to attend court. There was still mail being dropped off, there were still custody courts, there was still work to be physically done within a courtroom setting, even although, you know, some courts weren't physically sitting. There was still work that had to be done in the court setting.
I think you tell us at paragraph 15 that both SCTS and COPFS were, prior to the pandemic, very heavily paper-based at that time.
Yes.
What practical issues did that pose for members when restrictions were announced?
So, it was not an easy time, but I think everybody did a phenomenal job to transfer all of that business from quite an archaic system of working with paper to a digital and platform automatically. I mean, it was a huge piece of work for everybody to be able to do that, but it was not without its problems.
I think you tell us at paragraph 16 that there has been a lasting impact of the pandemic relating to COPFS in particular, that staff in higher grades working at home have adopted a certain attitude to staff that are based in the office. Can you tell me a little bit more about that?
So, as I said previously, before the pandemic hit, basically everybody had a requirement to be in the office or in court, and then we moved to people working from home more routinely during the pandemic, and subsequently everybody is now involved in a sort of hybrid model of working. But for those members of staff who were required to be in the court and those members of staff who were at home, there was constant demands coming back and forward about printing papers and posting out papers and doing stuff for people who were sitting at home, and they were going into that office every single day, and some tensions developed as a consequence of that.
You also comment that included members working very late or very early in the day. Was working early or late hours of the day something which members told you was an issue during the pandemic?
It was an issue because the schools closed, and if you had children, then there was a requirement for you to homeschool your children. So basically, both organisations operate a flexi time system of working. And pre-pandemic, that basically meant that anybody could start work between 7 a.m. in the morning and 7 p.m. at night. Clearly, if you were in an operational role in service in a court, you had to be in at particular times. And in the Crown Office, what they did is they extended that court time to 6 o'clock in the morning and to 10 o'clock at night. So if somebody had to take time out during the day to look after their kids or to homeschool them, then they were logging on and working maybe from 6 o'clock to 10 o'clock at night. Although, you know, there is a lot of evidence in our report that staff post-pandemic are still working very, very long hours in order to get through the work. I mean, they value the work that they do. They are dedicated to it. And it's the type of work where you have to be able to concentrate and not make mistakes. So people worked long hours when courts were sitting, and they are continuing to work long hours as a consequence of the backlogs.
And the backlogs, rest assured, is something which you come on to later in your statement and which I of course will touch on. I just want to draw upon something you say in paragraph 17 of the somewhat lasting impact of trying at least to move towards a paperless system. I think you say that in COPFS in particular, there's now really a patchwork of systems across the board, and some teams are paperless, some teams are not, and that's where we are currently. And I wondered if members had reported that as a particular problem.
It is a particular problem, I think, in both organisations, because there is not a kind of set process for this. It is entirely dependent on particular personal circumstances. Also, there are members of the judiciary who won't accept the digital stuff, who want to have the paper copies all the time. So there's no uniform system across any of the organisations, and it does come down to personal choice. And if you move around the organisation, then you have to adapt to that particular circumstance.
Within paragraphs 18 and 19, you talk about two specific changes to working which arose from the circumstances that the pandemic caused. First of all, as you've already discussed, core working hours being removed and that being a lasting change. And second of all, hybrid working, particularly in COPFS, again being provided as an option, and again that being a lasting change. During the pandemic, were both or either of those things reported to you as a positive change for the members?
It was a positive change if you liked working from home and you were able to work from home. It was a negative change if you were a new member of staff and wanted to get trained and there was no face-to-face training, you had to learn everything remotely. If you were in an operational role, it was a less positive change because you had to travel to work every day in an environment where people felt it was unsafe. So our members every day watched the First Minister gave her daily news conference, and you know that became very frightening for people at the time when day after day she was announcing 500 deaths, 600 deaths, 700 deaths, and people felt vulnerable because they were key and essential workers who were having to not only use public transport but go into a court setting which sometimes didn't always feel safe.
Again, those are matters, I think, which later on in your statement you go into slightly more detail about the anxieties of members, and I'm going to pick up on that. But next, in terms of what you deal with, you talk about the immediate effect of lockdown on staff, and again talk about at paragraph 26 there being really a split between those who are court-facing and non-court facing. There are a couple of groups that you tell us about in particular who found things challenging, and one of those that you mention is the Victim Information and Advice Team at COPFS. I wonder if you could tell me why you've identified that particular team as a group that was affected disproportionately perhaps by the pandemic.
Because they were the ones who had that interaction with victims every day. So there were changes every day. So maybe somebody was expecting a court to happen, and it didn't happen. It was adjourned for whatever reason. It might have been a COVID reason. It might have been an infection. So you were building these people up to giving them the knowledge that their case was going to be heard, and then it wasn't going to be heard. And for people, some people who have been waiting for justice, that was further delays, and they were very stressed about that. For other people who didn't actually want to engage in the process, they had to be persuaded to keep going in these circumstances so that cases didn't collapse. So, you know, in any one case, you know, there could have been several changes, and it was the staff in that particular area who had to explain and, you know, convince people to keep going with the process despite the number of changes that were made. And it was quite stressful for them because obviously the people that they were speaking to were agitated or emotional about short-term changes and things getting pushed back quite a lot of the time.
Another group that you mention in paragraph 31, about having a particular impact is those at a managerial level, both in, I think, in COPFS and SCTS. Why do you pick up on managers as people who had particular difficulty? Because
they were getting pulled in different directions in order to organise the work, so having to think creatively about how justice work could continue, so having that strategic overview about making sure that, you know, the work was delivered, and at the same time being able to have that role every day with staff, so they were getting pulled in lots of directions. And it's not uncommon in any workforce where managers are managing that, you know, sometimes that role that they have with staff becomes the bottom of the pile. So, you know, you do what you can, but when if you're dealing with a case and talking about a one-to-one with a member of staff or a performance management review, the performance management review and the interaction with staff will go to the bottom of the entry while you deal with the more demanding work. So there was not that same interaction with staff during this this whole crisis. And managers, I think, felt particularly stressed by that.
You go on at paragraph 34 to talk about a general sense from members that staff who were working in court buildings and physically turning up to court buildings each day required to, felt as if little, if any, understanding was given to the fact that they were carrying out what was essentially a frontline service. Can you tell us about that feeling amongst members?
Well, as I alluded to previously, they were watching these press reports. They were deemed to be essential and key workers. They were going into workplaces where not everybody was either, you know, socially distancing or wearing a face mask. There was also, you know, there were some cases where people were deliberately coughing or spitting, and, you know, I think the police felt a bit like this as well. There was a lot of emphasis on thanking and members of the public being grateful for all the work, the brilliant work that NHS staff did. But I think within the justice sector, which was still operating and people were still trying to do a good job, that they were basically not acknowledged at all for the role that they were doing in terms of making sure that justice was served in very, very difficult circumstances.
In terms of some of the protections that were put in place within the court service and within these particular workplaces, you discuss that at paragraph 35 of your statement, and one of the things that you say is in terms of social distancing and COPFS in particular, it was felt to an extent that lip service was paid to that, and I wondered what you meant by that comment.
Some people were just ignoring it. some people were not wearing masks. A lot of work went into adapting the buildings and to making sure that proper cleaning was in place and proper arrangements were in place, but some people were just ignoring it. The vast majority did actually, abide by the rules, but some people ignored it. There's no sanction for ignoring it, and it put other people at risk or made them feel vulnerable.
You go on at paragraph 36 to talk about there being in place an outbreak protocol or outbreak protocols between the organisations, but that at times they were not successful. What was being reported to you as the issue there?
So what was happening essentially is that if there was an outbreak or a suspected outbreak of COVID in a court, the Scottish Courts and Tribunal Service, as an employer, were dealing with that. They were making arrangements to have things deep cleaned. They were informing staff that there had been an outbreak. They were abiding by the protocols, but sometimes they weren't informing the Crown Office staff. So the Crown Office staff were turning up. I remember an outbreak in Kilmarnock Sheriff Court, actually, and the court service hadn't told the Crown Office that there was an issue. So the focus was on their own staff, but not their external stakeholders.
I suppose because there are so many different stakeholders working within a court building, sometimes the information sharing between those maybe not being as joined up as it perhaps could be.
And I think there's been a lot of lessons learned from that, there are multiple users of the building. I think communication has improved as a consequence, but I think it was very frustrating, particularly for lawyers in the Crown Office at that particular time. Excuse me.
I wondered if there was a sense that people generally, both staff and service users, were adhering to restrictions within court buildings.
I think generally people were, yes.
You spoke previously about there being instances, of course, I think as there were in all sectors of, or all buildings or all public spaces, where on limited occasions people didn't adhere to those restrictions. Did you have any experience of members being either disciplined or sanctioned for failing to adhere to guidelines or restrictions?
No.
Was there any anxiety between members about how or whether they could adhere to the guidelines that were put in place?
I think there was a small minority who didn't adhere to the guidelines and thought everything was an overreaction. But the vast majority of staff adhered to, the rules and the protocols.
There, I think, was a statement which you may be aware of from the Lord President at the time, which spoke about potential contempt of court proceedings in relation to people who were not following restrictions or guidelines. Was that reported to you to cause a particular anxiety to any of the members?
I think it caused a bit of anxiety to some lawyers in the Crown Office, because I think there was a worry and a concern at that time that if they didn't turn up at court, they would be found in contempt of court, but they might not have turned up at court because the workplace was unsafe. For our members who were in that environment, I think Lord Carloway's statement was welcomed. The fact that there were people routinely, users of the court, defendants who were turning up, no face masks, coughing, being difficult within the court setting, and our members felt vulnerable as a consequence. So I think his statement about people being held in contempt of court was welcomed by a lot of our members.
An indication perhaps that things were going to be taken very seriously.
Very seriously, yeah.
You say earlier on in your statement, and I want to jump back to a couple of comments that you make about sickness-related absence, particularly in COPFS. At paragraph 27, you say that your observation from members and the information you've received is that an immediate impact on COPFS was that there was a reduction in sickness-related absence. Do you have a sense as an organisation of why that might have been?
I think it was because people were not in that work setting. So if you had some sort of common illness that would prevent you travelling to and from the office, pre-pandemic, you wouldn't have travelled to and from the office. But if you had these sicknesses, when you were working from home, people felt more comfortable working from home rather than getting on public transport or whatever. But definitely there was a drop in some work-related stress amongst certain sections of the workforce because there was less court sittings and therefore there was less stress on them to deliver high pressure work at very short notice. But for some parts of the court service or in the VIA unit, that was the opposite because there was more and more delays. There was, cases that were never closed, new cases that were coming to fruition, and therefore their workload was just getting heavier and heavier.
I suppose what you're saying is the impact is not uniform amongst the different groups of within the organisations themselves.
Yeah. But in the VIA staff, I think there's about 73 across the whole organisation. So when you're talking about a few thousand staff, they've really felt the impact, but less so for probably the vast majority of staff who are working from home, and the number of courts had reduced for a period, and therefore they weren't under as much stress and strain.
Did the organisation observe a change when there was then a return to court business, be it online or some in person?
Since we've come out of the pandemic, the workplace stress, mental health and well-being, sickness, absence is going up again, and that's as a consequence of people having to cope with the backlogs and having to cope with new staff. There's a bit of staff turnover. I think a fifth of the staff in the Crown Office currently are new staff who have come into the organisation. Some people we allege, or we would say, have not been properly trained because there's not time to train people, or people are working in different circumstances. People are pulled from different areas into other areas, like the COVID death unit, which left a vacuum of experience in other parts of the organisation, where the more experienced staff have to pick up that pressure. So sickness levels around mental health and well-being are actually quite shocking now, particularly in the Crown Office.
And that's, I think, something which you mentioned later on again in your statement, which we'll come back to. I wanted to ask in particular about home working for the members of both SCTS and COPFS, because at paragraph 122, I think you identify some of the information which is required to be shared with the members or the members of staff who are working from home, and in particular court hearings which are occurring and were occurring remotely, are in relation to issues which are quite often confidential and sensitive in nature. I wondered if members experienced any issues with privacy if they were required to work remotely.
I think some people, that was across the piece, that you've got members of staff in both organisations who maybe had a spare room or a spare cupboard that they could work out of and could have some privacy, but you have some people who didn't have that, who were working at kitchen tables or dining room tables, younger members of staff who were sharing flats with people who still had to work from home. So there was a concern. It's a standard concern that you get when you get a laptop and you have the ability to work from home, it does come with these warnings that you're dealing with sensitive information and therefore you've got to treat it in confidence. I mean, I think staff understand that, but, you know, in these circumstances, some people had no choice but to, you know, work in the same environment as members of their family who were also working from home.
You then, I think I would go back to earlier on in your statement, because at paragraph 40 you discuss steps that the organisation took in May of 2020 to essentially get a feel for what the membership were thinking about their employers and returning to work at that time, because I think that was around the time that there was an expectation that certainly a proportion of members returned to their workplace. You say that you conducted a survey of the members, and I wondered, first of all, can you tell us what the purpose was of that?
We wanted to gauge members' views on how they felt about going back into that workplace. There was a bit of a push to try and get everybody back at that time. So we felt it was important that we had to understand what members' concerns were, and we had to have that engagement with the employer to make sure that these concerns were addressed. Because, you know, people still felt vulnerable at that time, but we needed to be clear what these issues were in order to make any adjustments that had to be made by the employer.
You explain that 466 members took part in that survey, and your statement gives quite a detailed list of the questions that were asked and the individual responses or the proportions of responses from members. But in general, I think if we look at the responses given, am I right in that we see perhaps an anxiety amongst members about returning to work in person at that time?
Yes.
Can you tell us some of the reasons why members were reporting feeling like that?
Well, the virus hadn't gone away, so there were still people who had coronavirus. There were still people attending court who had suspected coronavirus, whilst there was a lot of face masks and hand gel and testing kits available. People did feel vulnerable, and I think there was a feeling that in the pandemic circumstances, the numbers of people attending the office was much more controlled at that point than it was going to be post-pandemic, and there was a bit of a drive by the Chief Executive of the Court Service to try and get people back into that environment, but people didn't feel safe.
You tell us at paragraph 41 what your organisation did as a consequence of that survey, and you say that you worked with both COPFS and SCTS to discuss safeguards that could be put in place in order to reassure the members. Are you able to tell us some of the things that you were able to agree with both of those organisations? We worked together, and what trade unions and management call a partnership way. It was in everybody's interest to work together to get good outcomes and for everybody to feel much better in the workplace. So if people contracted coronavirus, that they were open and honest about that, but it wasn't marked against your sick leave record, although you were off sick. It wasn't marked against your sick leave record, because a lot of employers have what we call sickness absence trigger points. So if you go beyond 7 days, then you start to have this engagement with HR about why you had 7 days sick leave. So the COVID sickness was not counted towards that because of the guidance that was set down by the NHS about the period in which you had COVID and you didn't have COVID. We needed to make sure that the workplaces were safe and that the correct cleaning environments were in place. There were too many staff
for the amount of desks that they had. So hot desking regimes were brought into place, but you had to have systems in place whereby if I attended the workplace and worked at a desk, so we introduced a system of I worked away at a desk and left that desk for the day, that I would turn over a card to say this desk needs cleaned, so that the next person knew that it was cleaned or they didn't sit at that desk. So, you know, lots of stuff like that. Just making sure that people had a confidence in working in that environment. And the employer, I have to say, was very good. Both employers, I think, were very good in terms of the arrangements that they had with our reps on the ground and trying to address. You always get people who try and, you know, ignore the guidance that is out there. And when that came up and we raised it with management, you know, that was sorted out quickly as well. So it was, you know, people in these workplaces have very stressful jobs. You don't want to add to their stress by making them feel worried or concerned about the environment in which they're working in.
And I think you acknowledge at paragraph 42 of your statement that generally the measures and the safeguards which were agreed to be put in place were complied with by both of those employers. Yeah, so what we did at Scottish Government level is we prepared a set of coronavirus protocols, and the background to that was that they were based on a lot of the guidance that was coming out of the NHS and the statements that were made by government ministers. So we had a core protocol, and we updated that every time there was a change. So sometimes it could change weekly, sometimes monthly, and we developed that at the centre, and I was on the negotiating team for that. And once that was developed, then it was cascaded to all employers across the Scottish Devolved sector and all the civil service areas and all the justice areas. And what it meant was that these were the protocols that had to be adhered to, and it saved us having to go into negotiations on 42 different employers to get the same outcome. And then once these were cascaded to the employers, some employers, I think the Scottish Court Service in particular, just put their logo on it and circulated it to staff. I think the Crown Office didn't do as much of that. So, yeah, everybody worked really well to make sure that these protocols and principles were in place. You know, they were challenging times. I mean, there was times when people were being asked to take their annual leave when they were stuck in the house. They had nothing to do and they had nowhere to go. So obviously people wanted to save their annual leave when everything started to open up again. But, you know, there were some employers who were saying to staff, you need to take your annual leave. Nobody can carry over all this annual leave. We don't know what the end game is. And there was a lot of that going on, you know, and, you know, there was a lot of pressure on some staff to attend the office who felt that they had vulnerable members of the family, that they were worried about perhaps catching something and bringing it back home to an elderly parent or a vulnerable child. But, you know, the employer, at the end of the day, their priority is to get the work done. We had to work with them to make sure that what they were doing was open and fair, and was sitting alongside the protocols and the guidelines that were developed. You mentioned earlier in your evidence about the status of COPFS and SCTS staff as key workers. And I wonder if you had any information about how that affected members, both positively and negatively, if there is any negative impacts.
Well, to be a key worker, the employers had to, like other employers, have a letter printed which confirmed that they had key worker status in case they were stopped by the police travelling to and from their work. I think a lot of people do recognise that they are an essential workforce at the end of the day, and they recognised the status that they had, and they also recognised that some people had to go into the office to make sure that the justice system kept operating. But I think there was a complete lack of acknowledgement of the work that they were doing, that was essential work. A lot of people don't understand how the justice system works. Most people don't actually interact with it, and therefore they have a key role in society to carry out the work that they do, but I don't think they felt that it was properly acknowledged.
When you say properly acknowledged, do you mean a kind of generally by the population at large?
By the population at large, by Scottish ministers and by the employers.
I think you go on to talk about vaccination, and I think you say in relation to both COPFS and SCTS that it's your understanding that nobody within either of those services were given a priority for vaccination.
No, they weren't.
Is that something that was reported to you as an anxiety for members?
No, not to me personally. I think that people were given the time off that they needed when they were called by the NHS to get vaccinated, but there was no pressure on me to go to the employer to say that they should get priority.
You also discuss shielding and how each organisation had a system whereby they identified staff who felt vulnerable and uncomfortable in returning to work, and attempts were made to accommodate that. And I think generally you comment at paragraph 75 of your statement that really shielding was handled quite well and fairly by both organisations.
Yes, I don't think there's any doubt about that, but equally if you had an illness like COPD or asthma or any kind of vulnerable illness, you also got a letter automatically from the NHS to say that you were into this category. So both organisations respected the fact that some people were vulnerable and it was best that they worked from home.
There is a section in your statement which discusses the effect on service users of the pandemic as observed by the organisation. Now, naturally, of course, the interests of PCS are in line with the members that it represents. But I think at paragraph 38, you acknowledge that the biggest impact was probably felt by victims of crime who are having to wait for access to justice. You already, I think, have discussed this in terms of the Victim Information and Advice Service, but I wondered if, in relation to any other aspects of SCTS and COPFS, were there instances of staff having to come into contact with service users who were expressing that they were unhappy with the changes that had been made?
In terms of?
In terms of court closures, for example, or people who had to wait for access to justice.
I mean, there was an engagement with these people, so there was an explanation given about delays or adjournments or postponements, and not everybody was happy with that. So some people were obviously understanding, and other people were less so, and some people were just agitated or emotional because they were being reminded of a crime that had been committed against them, so they were in a vulnerable position. Some people don't want to engage with it, they have to be persuaded to engage with it. These staff had to keep them on board, otherwise cases would collapse.
To kind of expand on that and talking about perhaps the longer term effect on the justice sector, at paragraph 43 you explain that one of the significant and most enduring issues for the members relates to the backlog in cases and the need to reduce that and the pressures which come with that. You acknowledge in paragraph 44 that court backlogs predated the pandemic. But you go on to say that the disruptions necessarily meant that they increased. Are you able to tell us what members identified to you as issues relative to their work which were caused by the pandemic in particular?
Well, cases were being adjourned and they weren't being held, and, you know, the business wasn't got through at the pace that it used to get through, so, and new cases were coming on stream as well, so people's workload was increasing. So, you know, it's still an ongoing, it's a huge issue. I mean, there is no doubt that our members have done an amazing job in clearing, you know, a huge part of that backlog. I think in 2 years, something like 20,000 cases were cleared, but there's still a huge backlog ahead of us. Our members are working as hard as they can, but there is not enough of them to clear these backlogs. You know, the Scotsman this week has been running 5 days of what that looks like. I think the Crown Agent today has said that the amount of High Court trials will need to double between now and November, but we've not got the staff to do that, and that is just going to make quite, you know, a difficult problem worse. You know, they are working at pace, and I don't know how we're going to deliver more of that in the next 9 months.
One of the things you talk about in particular in your statement at paragraph 102 is the creation of the COVID death investigation team. So I think it's called CDIT as an acronym. And His Lordship, I think yesterday, heard details about the work of that team and the purpose of it. But I wondered from your perspective and from members' perspectives how the creation of that team impacted upon staff at the time.
So it was obviously a new unit that had to be staffed, and from my understanding, the way it was staffed was that people were pulled from other areas of the department and put into that staff, which created a vacuum where they left. So they were either replaced by a new member of staff or no member of staff. And, you know, while the court service and the Crown Office in the last few years have increased the number of staff that they've got, there is not enough. But as this unit winds down its work, then these staff will move back into core justice business. But they took out some of the best trained staff with the longest service to deal with that, and that left a vacuum elsewhere.
You have discussed already the perhaps an enduring impact of, at least contributed to by some of the measures that were put in place by the pandemic, and you, in your statement, you talk about a survey that was conducted in 2024 of members. You talk about that at paragraph 46, and the findings of, I should say, of that the inquiry has and is summarised within your statement. But put shortly, am I right in saying that PCS members are reporting in 2024 that they are still feeling the effects of the pandemic in terms of the justice sector?
If anything, it's worse now, because the backlog is there. The digital and IT systems in the court service and the Crown Office don't speak to each other. The training is not adequate. There is not enough staff in place to clear that backlog. I have reports regularly of staff who work to midnight, and you know that might be something that is a routine for a lawyer. It is not for admin or executive officer staff who are kind of low-paid members of staff. I've had an instance recently where people are building up so much flexi time that they're losing it. So the court service and the Crown Office are working on the goodwill of staff. They are they are clocking up so many hours, they're not allowed to take that time back. There's restrictions on getting paid for that time because of overtime, and the fact that both organisations don't have realistic budgets for it. So there are massive problems. I mean, that report, you know, the consultants worked with our members over a period of about 18 months. We have given that report to both the Crown Office and the Court Service. I've got a meeting with the Crown Agent on it on this Thursday. I've met with the Chief Executive of the Court Service. I don't think any of the issues that are contained in that report are a surprise to both employers. In fact, both employers gave evidence to the Finance Committee in the Scottish Parliament recently about the budgetary pressures that are on them. I equally acknowledge that you've got archaic IT and digital systems that are in place, and you don't just snap your fingers and that they're replaced overnight. It's going to be gradual. But the toll that is taken on staff in there and the staff that are leaving is something that has to be taken seriously. A fifth of the Crown Office staff have been there for less than 2 years. You're losing that expertise. People are saying, why would I want to work in this environment when I can go as a civil servant and go and transfer to another government department with less stress and strain?
And I think there's a final section of your statement in which you talk about lessons to be learned from the pandemic, and we've covered, I think, quite a lot of those lessons thus far. But at paragraph 118, you say that really the main lesson to be learned is that there should be better funding for the justice sector to ensure that there's, at a normal time, there is not backlogs, so that if another pandemic or other event ever happens, the sector will be better placed to deal with it. Is that something I suppose you've repeated it a number of times in your statement, something you feel strongly about? Absolutely. You know, I think some employers are beginning to learn and have set up resilience units or have set up emergency response teams. In fact, you know, I know that the Court Service have, because they've recently in the Inverness Justice Centre had an outbreak of radon as a kind of gas that's leaking into there, and they have an emergency response to that. I don't know about the Crown Office, but, you know, people need to reflect, if they've got the time to reflect, on what could be done better and what lessons could be learned, and the communications channels between each of the stakeholders within the justice sector and the justice sector pipeline need to be at the forefront of any discussions going forward, because, you know, if communications had been better, then I think it would have been an easier process for some. So hopefully, but, you know, a lot of pandemic planning or emergency planning goes on behind closed doors at a senior level, and people are not aware of it. So you have to hope that that is something that somebody is doing. Where anybody gets the time to do that in the Court Service or the Crown Office is beyond me. Their full concentration at the moment is on seeing justice delivered. We've covered a lot, and I think those are the areas in which I would intend to ask you questions about, but is there anything else in particular, for example, reflections or lessons to be learned that you wanted to raise? I think for me, you know, coming here and discussing the impact on my members and the staff generally in the Court Service and the Crown Office, you know, I think, you know, I really want to acknowledge, you know, the dedication and hard work of the staff in both organisations and the good partnership working that happened at the time, and to have on record at a formal inquiry that their work is very much appreciated. Thank you very much. Unless your Lordship has any further questions, no, that was all I would intend to.
Thank you very much indeed. Thank you, Ms Dunn.
Thank you.
Very grateful. We'll break now and come back at 1:30. Thank you.
Thank you. All rise.